CR 1470 for the offense of burglary of a habitation on October 2nd, 2019 for a term of 8 years. Is that you?
Yes, I am, Your Honor.
All right, state.
Violated condition number 4 in Barrett County, Texas. The defendant Kendrick Parnell Williams then and there failed to report the supervision officer as directed for the months of April, May, and December 2023, January 2024, in violation of condition number 4.
How do you plead to that? True or not true?
Notice how quickly this hearing turns serious. 1 yes confirms his identity, and suddenly the judge is reciting years of supervision and violations. This is where most defendants start realizing mistakes are real.
True.
Your Honor, the state waives all the violations.
Any objection?
No.
Did you understand by pleading true to violation of condition number 4, court could find it true, grant the motion, sentence you to 8 years in the prison and a $1,500 fine?
Yes, I do, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
That is correct, Your Honor. True.
Do you wish to plead true to number 4? Knowing that? That's yes or no?
That's a heavy warning shot. Pleading true could land him the full 8 years. Judges often spell this out so defendants can't later claim they didn't know the risks. Question for you, would you take the deal or fight it out in court?
Yes.
All right. Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor. The proposed agreement is for the defendant to enter into the safety relapse program.
All right. And are you asking the court to follow that agreement?
Yes, I am.
Are you waiving your right to appeal?
Yes, I am.
All right. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right. You can lower your hand. State your name for the record.
Kendrick Parnell Williams.
All right. So, Mr. Williams, what is going on with you? Why are you not being successful? Because this is not the first time you've been brought back here. What's going on in your life?
Here's the emotional pivot. Williams opens up about mental health and addiction. This is where the human side of these hearings surfaces. The court has to balance compassion with accountability, and that's never an easy line.
I have had mental breakdowns.
Mhm.
I'm not proud of my drug addiction. I just had setbacks, tried to get correct and be successful. But I'm here in front of you, accepting my wrongdoings and being a man about it and asking for help.
All right. But this is what I don't understand. You didn't show up, so you've been missing. Why don't you pick up the phone and call probation and say, I'm going through some things?
May I say something, Your Honor?
Sure.
I did. I don't know if it was recorded or not, but I thought I was calling the right numbers. Miss Mendez, my PO. I was in the San Antonio Behavior Center through those procedures. I was as well in lifetime recovery. I have to accept my wrongdoings as a man.
All right. So here's my thing. Did the probation you thought you were calling, did they respond to you?
No, they didn't. I was at Haven Pro.
All right. So here's the thing. If you call probation and they don't respond to you, what do I always say? If you have an issue and you call probation and you feel as though they're not responding or they're not addressing your issues, you can always come to court. We're here Monday through Friday. Why didn't you do that?
I was confused, but that doesn't make no excuse.
All right. Probation?
Yes, Judge.
What are you suggesting with Mr. Williams?
Judge, at this point,
Because I ordered him for drug court and I also ordered him for safety special needs if he didn't
yes, Judge,
make it in felony drug court.
he completed, so he was not eligible for DDRF. We tried to get him there. He did complete 277 days of safety. He spent 48 days in the residential aftercare with safety. He was discharged unsuccessfully from drug court. We reached out to drug court to see if they would accept him back, and they said no, not at this time.
Mhm. So why was he discharged from felony drug court?
Did you catch that? He's been through multiple rehab and recovery programs, yet keeps relapsing. Courts usually give chances, but repeat failures stack up quickly. How many chances do you think someone should get before prison becomes inevitable?
From my understanding, Judge, it was drug use and his behavior
Okay.
was combative.
I don't know if this is going to work for him.
All I can say, Judge, is I was reading the notes. I believe that in addition to lifetime recovery and also ITP at Haven for Hope, Mr. Williams also self-admitted himself into the program at Salvation Army. Is that correct?
I did.
Okay. So I think it's apparent that what we're dealing with, Your Honor, is a situation where we have an individual who is not only suffering from apparently an untreated, unmanaged mental illness, but more importantly, a drug addiction that is, whether it's more powerful than he can handle or he gets relief for his mental health issues from that drug use. I don't know. But what is apparent is that every opportunity for help that's been offered to this gentleman, he's taken full advantage of, with the potential exception of jail court. I know at least part of the reason why they won't accept him back is that they're at capacity right now. But this is an individual who is not in front of you because he's committed any new offense. He's here because he is struggling without a home, without adequate care for his mental issues, and with a serious drug addiction. And even among all that, even dealing with all that, he's still admitting himself to treatment through Salvation Army, what he can do. So, Judge, he did successfully complete.
The defense is making a strong case. He hasn't committed new crimes. He's battling addiction. That's a crucial distinction. This moment really asks, should the justice system punish relapse or keep trying rehabilitation?
SafeP once. There is a relapse program. I would argue there's a relapse program because for a reason. Sometimes that is necessary. I would hope that it could be effective in Mr. Williams' case, and I think it would be a minimal burden to take a chance on him to at least see if we can give one more shot at recovery, especially considering the fact that we're not here for any new offense.
All right. Anything else you wish to say, Mr. Williams?
Yes, ma'am. As of August of last year, I did complete lifetime recovery.
All right. So I'm going to give you a choice because sometimes I can give people choices. Sometimes I cannot give people choices. It appears that there's really no place to help you, right? And the reason why I say that is because you were placed in felony drug court. Then there was an issue. And then you've done SafeP. Then you've done Haven for Hope. And I have all this written on the docket sheet where I've done my best to address whatever issues you have, and hopefully you can go forth and be a productive member of society. So I can continue, place you in relapse SafeP program, or I can sentence you to 3 years. And you'll receive credit for the inpatient treatment time that you've done. So those are your two choices.
And there it is, 3 years, not the full 8, but still prison time. Notice the judge gives credit for treatment already completed and even offers therapeutic community support inside prison. This shows how judges sometimes mix punishment with a last shot at help.